confront Carmelo Anthony after he stabbed Austin Metcalf at this track meet. This body cam captures the moment that Anthony made this now infamous statement, quote, "I'm not alleged, I did it." And you heard it clear as day on that body cam.
To test every lock. Before we go deeper into what the documents actually show, make sure you're subscribed to Audit the Case, because we don't just cover the story, we follow the evidence.
Right now, Carmelo Anthony is currently living in a rural Texas medium security prison. It's about 3.5 hours south of Frisco, Texas. That is where Anthony used to live. It is where Anthony stabbed Austin Metcalf in the chest at a track meet. And it was a wound that killed Austin Metcalf. And of course, this all happened, and we've talked about this story a lot, after Carmelo Anthony ended up under the tent of Metcalf's team at this track meet, and he wouldn't leave. The state said that Metcalf then confronted Carmelo Anthony, that he shoved Carmelo Anthony, and Anthony responded with a knife that was in his backpack, striking Austin Metcalf and giving him an injury that the medical examiner says there is no way that Austin Metcalf would have survived.
The underlying facts of the case have been heavily debated since the trial concluded. Prosecutors argued that Anthony stabbed Austin Metcalf during a confrontation at a Texas track meet. The jury ultimately accepted that version of events and returned a guilty verdict after only a few hours of deliberation. The punishment phase moved just as quickly.
Carmelo Anthony's trial lasted 4 days. When it came to the testimony, it took the jurors about 3 hours to find him guilty of murder. Then it was another 3 hours that same day, roughly, for them to determine that his punishment would be 35 years in state prison. It could have been as many as 99 years. Now, the day after his sentence, Carmelo Anthony filed a notice of appeal from prison, and he wrote in that notice of appeal,
within the same day, the jury imposed a 35-year sentence. For the Metcalf family, the verdict represented accountability. For Anthony's supporters, it raised new questions. And those questions are now moving from social media into court records. Because shortly after sentencing, Anthony filed a notice of appeal. That filing matters.
Murder. But now, Carmelo Anthony has a high-profile team of lawyers who are preparing to challenge that verdict. We received an email from the Stand with Carmelo Coalition, and this email announced 6 lawyers will conduct a fresh, independent review of the trial record. It goes on to say, quote, "We recognize the profound loss suffered by one young man's family and the uncertainty facing another, and we extend our respect to everyone whose lives have been forever changed by these events." So this team of lawyers, they will be serving pro bono, according to the email. Now we're going to go.
The appeal process is now underway. And that process operates very differently from the trial the public watched unfold. At trial, the central question was simple. Did the state prove murder beyond a reasonable doubt? On appeal, the question changes. Did the legal process contain errors significant enough to undermine confidence in the verdict? That distinction matters.
So they're going to be looking at the record itself, Chris. This isn't going to be a situation like much of the public is doing, where they're looking at, well, why didn't the defense argue this, or why didn't they argue that? What they're going to look at is really errors within the record, both constitutional errors and structural errors. So did the judge allow hearsay in against the defense's objection? Was there a jury charge instruction that was let in that shouldn't have been let in? I think we'll probably see an objection to the judge's ruling on the Batson challenge. The defense did object. They did make a Batson objection, and the judge overruled that objection. So I'm sure we'll see that as being one of the issues that the court rules on, in addition to a number of other issues, probably a sufficiency of the evidence argument, and then various other pieces of evidence that probably came in that the defense will re-urge their objection.
The record is another. The record is another. That phrase may end up defining everything that happens next. Public discussion often focuses on evidence that people can see. Video clips, witness statements, body camera footage? But appellate.
Sure. So in jury selection, you cannot make you can't strike somebody on the basis of gender or race. You have to have a gender or race neutral reason for striking that person. So in an instance of a trial, if the prosecution strikes a few, we'll use in this case, for example, they strike a few black jurors, then the defense might think, hey, well, the prosecution struck black jurors because they're black. And so they can make a Batson challenge. The burden then shifts to the state to provide the court with race neutral reasons for having struck black jurors. And so in this case, I think the state argued that they struck these jurors because they were educators of young children or kids, and so they felt that they wouldn't be good jurors in this case because they might be more sympathetic to Mr. Anthony. And the court found that that was a
Batson challenge during trial? That sounds technical. Because it is. But the concept is straightforward. The law prohibits jurors from being excluded solely because of race. When a Batson challenge is raised, the court must evaluate whether race-neutral reasons justified the strikes in question. The trial judge rejected the defense challenge. That ruling now exists inside the appellate record.
Times end up doing.
Well, with a team like this, you should expect they're going to lift up every rug, and they're going to look under every rock and, make sure that no stone's unturned. And a lot of what they're doing, because it's a serious hurdle in an appeal, right? Because with these constitutional errors, sure, something might be wrong, but not only does the defense have to prove that something went wrong, a piece of evidence was let in, a juror was allowed to testify regarding certain conduct, an instruction got into the jury charge. They also have to prove that there was harm, that error caused harm, and but for that error, we would have or could have had a different verdict. And so it's a really high burden for a defendant on an appeal, but they're also preserving the appellate record for...
Whether it becomes a significant issue on appeal remains unknown, but it illustrates how appeals work. They focus on decisions, not...
Well, it'll be the appellate court justices. And so they'll look back. First, the appellate lawyers for Mr. Anthony are going to have to make the arguments. They're going to have to raise these issues. The issues that they raise are going to have to be issues that were previously raised in trial for the most part, right? And that's why it's so important, like I talked about earlier with the prosecutors and keeping a clean record, it is crucial that the defense attorneys in this case make the objections when necessary, because they know they've got to preserve this record for appeal so that they can give the appellate lawyers the ammunition they need to make the objections to the appellate court. But ultimately, it will...
Not public opinion. And there may be additional issues under review. Evidentiary rulings, jury instructions, constitutional objections, questions involving preservation of error. The list could be extensive, or it could prove insignificant. That uncertainty is exactly why appellate review exists. Now, consider the broader...
Because post-verdict, we've seen so much debate from people who were just following this case to columnists of all different kinds, legal analysts about the facts of the case and everything that went down in the trial. And then, now the body cam and surveillance video was released in the last couple of days. So people are looking at that too. But in an appeals process, what will Carmelo Anthony's team actually be looking at to...
Years of litigation could follow. Direct appeals, potential post-conviction proceedings, additional filings, additional reviews, additional rulings, which raises a question that transforms this case from a courtroom story into something closer to a legal thriller. What if the most important decision in this entire case has not been made yet? Because the conviction may already exist.
The appeals process on a 35-year sentence can take a really long time. Now, there's stages of the appeal process. There's the direct appeal, and then there's the post-conviction appeal. And so the direct appeal is a lot quicker than the post-conviction appeal. When the appellate court affirms the trial court's decision, then the case that's deemed a conviction, and then the defendant, under Texas law, would be entitled to file a post-conviction writ of habeas corpus under 1107. That process takes a lot longer because in that process, it actually allows the parties to investigate and create a record. They can get affidavits from new witnesses. They can get affidavits from witnesses that may have provided the defense evidence that the defense chose not to use in trial. They can get affidavits from the defense attorneys themselves where they're explaining the strategy behind their decisions in trial. And so you build a lot larger record. That investigation takes time, and you can file in certain
Years of litigation could follow. Dallas did not testify in his own defense. The public often interprets that choice emotionally. Appellate courts do not. Courts generally treat trial strategy with substantial deference. Lawyers make judgment calls. Some succeed, some fail. The legal standard for overturning a conviction based on ineffective assistance of counsel
It isn't fair a lot of times. But there is the decision that was made, and whatever went into that decision, it's kind of unclear of why Carmelo Anthony did not testify in his own defense, since he was, really the closest witness to what happened. And if you're alleging that you were afraid for your life and you needed to do this to protect yourself and all of that, I think jurors would have really liked to see that. First off, let's just talk about that decision in and of itself. Like, what did you make of the decision for Carmelo Anthony not to be on the stand?
Well, I agree with you, Chris. I think any juror is going to want to see that, and I'm sure the defense probably went over that issue during jury selection, and weeded out or tried to weed out the jurors that would hold that against the defendant if he didn't testify. But people slip through the cracks, and so I think in this day and age, if you're arguing self-defense, people want to hear, well, what made you so scared that you felt the need to use a knife?
Years of litigation could follow. Kinnier did not testify in his own defense. The burden is much higher. Much higher. That reality may frustrate supporters and critics alike, because appeals are not designed to revisit every tactical decision. They are designed to identify legal error. And proving legal error is only half the challenge. The defense must often demonstrate that the alleged error mattered, that it affected the outcome, that without the error, the verdict might have been different.
So no, Chris, it wouldn't. That would be an ineffective assistance of counsel claim that would likely be brought up during the habeas corpus part of an appeal. But assuming that we were there, that's probably not going to be a winner argument, because the attorney's going to provide an affidavit and state that here was our strategy based on the evidence that we had, the evidence that was in at trial, and our woodshedding in preparation of the defendant. We did not feel that it was the best strategic decision for him to testify. That's different than if the defendant wanted to and they forced him not to, right? Because in the end of the day, the defendant has the absolute right to go to trial. They've got the absolute right to testify in their defense. And so if they didn't provide him that opportunity, then
That is an extraordinarily difficult standard, which brings us back to where this story began. A conviction.
it's an unfortunately really low bar. I think that there's a case where a defense attorney was asleep during trial and was not found to be ineffective, not found to have provided ineffective assistance of counsel. So, but on the less extreme side of things, as a defense attorney, you've got to make judgment calls based on your experience and based on what's been put into evidence before a jury. And so the courts really do provide a lot of deference to the decisions made by the lawyers. And so it's a really high bar.
But the final judgment on whether that conviction survives appellate scrutiny remains unwritten. That is the ticking clock, not the verdict, the review. And there is another layer to this story that deserves attention. Some observers have questioned strategic decisions made during trial. Most notably, Anthony.
We're talking about numbers.
Yeah, no. That's a good point. I hadn't thought about that yet. And we'll see what happens. This appeal process, certainly a high-powered team, but what impact will it make in the long run?